Hello. In this video, I'm going to explain 5 effective strategies for defending a drug possession charge. This is a very common charge. Police go after this crime very frequently here in Arizona. I am a criminal defense lawyer and owner of Future First Criminal Law and have successfully defended many of these cases because, quite frankly, they're just so prevalent here. This will hopefully go through and explain kind of some of the ways to challenge it within the court system, within plea bargaining, within the prosecutor's realm, and kind of once you hear this, hopefully you can, if you can't do this yourself, you'll look at this and go, this is why you should hire a lawyer. And contact my firm for a free consultation. I'm more than happy to help you out here. Anyways, I've created this template that goes through step by step. I will go through and essentially read off everything that I've laid out here for you. That way you can try and understand a little better of what goes on in a drug possession case. First of all, this is kind of the background. The police tell you they've found drugs in your home, vehicle, pocket, or purse. You're arrested and charged with possession. The prosecutor has offered you a deal. Should you take it? The answer is not before getting your case assessed by a criminal defense attorney. A defense attorney may be able to raise some strong defenses that could win your case or at least get you a better plea offer. That is essentially the name of the game for defending drug charges. Now, 5 possible strategies to consider. I have laid out a table of contents over the 5 that we will be going over. First one's ask the court, the judge, to suppress the evidence. Number 2, challenge the prosecutor's evidence of the possession. Number 3, challenge the prosecutor's evidence of knowingly possessing the drugs. Number 4 is challenge the prosecution's identification of the controlled substance. Number 5 is consider the diversion program if one is available. Keep in mind, this is a big overview. I don't go into the specifics of every scenario, of every situation. Everybody's case is different, which is why it's very important to consult a lawyer. If you've been charged, before you take any deals, before you go to trial, you can get second opinions. Everyone should be offering free consultations. If not, there is a case assessment available. Either way, you're going to really want to know and get a deep dive into your case, which is what your lawyer should be helping you with. All right, first, ask the court. The court's also referred to as the judge. Ask the judge to suppress the evidence. If the police violate your constitutional rights when they seized the drugs you are alleged to have possessed, you can ask the judge to suppress the evidence. In the right case, a motion to suppress, which is what you would file, can be especially effective defense to drug possession charges. If the motion to suppress is granted, the case will probably be dismissed without a trial. The prosecution cannot use evidence gained by violating the law. AKA, the police violate your constitutional rights. That's how they possess the drugs. The judge says, yes, I agree. It was a violation. The judge doesn't let those drugs come into a trial per se. Now the prosecution has no drugs that they can present as evidence. So, in essence, your case would be dismissed. Continuing, therefore, the substance that was illegally seized cannot be admitted into evidence, nor can the results of the lab test conducted on a substance. We'll get into the lab tests a little bit later. It's very important there. Anyways, search warrants. The Constitution prohibits the government from conducting unreasonable search and seizures. As a general rule, police are required to get a warrant before searching any place or items within a person that has a reasonable expectation of privacy. AKA, we're talking about your home, your office, hotel rooms, luggage, sealed packages, mail are some of the main examples. Of course, there are a ton more that go into it, different scenarios, so on and so forth. To get a search warrant, the police must usually provide a judge or magistrate with 1 or more affidavits, basically written statements that they swear under oath are accurate, reporting the observations of confidential informants, private citizens, or police officers. The affidavits must provide probable cause to believe that search warrant will reveal the contraband or evidence of the crime that is essentially alleged in the affidavit. Search warrants pursuant to a warrant. Searches pursuant to a warrant can be attacked for several reasons. For example, the affidavit may contain false statements or fail to establish probable cause. The warrant may be sufficiently specific, or the search may be beyond what the warrant allows. So if the warrant isn't specific enough, that's going to be a problem. If the warrant is specific, but the police exceed the search beyond what is allowed, beyond what the judge or magistrate allowed in the warrant, then that could be a problem for the police. Great for you. Warrantless searches. Not all searches require a warrant. Many exceptions allow the police to conduct warrantless searches. The rule of warrantless searches are sometimes vague and not infrequently police exceeded permission bounds. I don't remember when I was writing this. There's so many things going on, but essentially there's plenty of ways to get a warrantless search. I'll go through a handful of them. These are the ones that often are done with consent. So the police do not need a warrant or probable cause to search a person or a place when the person with the right to do so consents. Consent must be given freely and voluntarily. Consent extracted by intimidation, lies is not valid. Some of the key things to think about here, this is person. They're talking about searching your body, your pockets, a backpack, any of the items that could be on your person. And then places such as a home, a vehicle, different things there that common people might think that they have a right to, don't have a right to. Just know that if you give somebody permission, the police permission to search you or to search something else, you basically give them everything they need, and they don't need to go get a warrant. I'll go into some of the examples and things in this later because it gets a little interesting here. Something to think about too, and this is where a legal justification or a legal challenge would be made, is if somebody gives the police permission to search something, but that person didn't have the lawful authority to give that. So for instance, I can't go, yeah, go and search my neighbor's house. That just would be an impermissible reason for the police to rely on. Anyways, the drugs are in plain view. This plain view exception here. When the police are in a place where they are allowed to be, they can seize evidence that is in plain view. They must have probable cause to believe the item they seize is contraband or evidence of a crime. This is very typical of the car scenario. You're pulled over, you don't have window tints, police can see right into your vehicle, and they see drugs laying about. Right then and there, you're going to get some of the plain view rules. Search incident to arrest. When police lawfully arrest someone, the area is accessible to the arrestee, can be searched incident to the arrest. If the arrest is without probable cause, the evidence obtained during the search can be suppressed. Get more into this a little later. Automobile search. An automobile that is readily mobile. It's important, keyword. Can't be, it can be parked, but readily mobile. So if it has no wheels, no tires on it, such as a mobile home that has been converted into a residential home that is never moving, wouldn't be allowed here. Anyways, an automobile that is readily mobile may be searched without a warrant if there is probable cause to believe that the vehicle contains contraband or evidence of a crime. If the vehicle is validly stopped, the passenger compartment may be searched for weapons or for the officer's protection if the officer has reasonable suspicion that weapons will be found. Low level of cause there. Basically, it's a Terry frisk there, which is going to go into next. Allowed to pat you down, search for weapons, and under the simple premise that there could be weapons. Police may frisk a suspect when they have reasonable suspicion that the person is armed and dangerous. The frisk is a limited pat down for weapons. I go into a lot of this in some of my other videos as well. Common scenarios. This is kind of your everyday things that will happen in many situations. The outcome of a motion to suppress can never be guaranteed, of course. However, there's some of the common scenarios which police arguably overstepped, and a motion to suppress has a good chance of success. They're by no means the only situations in which a search can be challenged. Keep in mind here, everything goes to the judge. The judge in the motion to suppress is the one who has the end decision of what's going to happen. Of course, there are challenges if you don't agree with the judge's ruling, appeal, so on and so forth. But it's not like there is one law where this is exactly what happened and it automatically has to happen. It's what your lawyer, or if you represent yourself, has to prove to the judge. And keep in mind, the prosecutor is going to be challenging you really as hard as they can to make sure the evidence does come in. The police ask for one of the scenarios. The police ask for permission to search a person's home, car, office, hotel room, etc., and she agrees. The drugs are found. but she agreed only because she was intimidated or tricked. For example, the officer asked with his hand on his gun and didn't tell her that she had a right to refuse. Or the officer falsely told a woman that he could get a search warrant when he could not, or falsely told her a drug dog had alerted. So this is something that is definitely on the higher end of looking into a case. There's this general premise that this is a reason that a motion to suppress would be valid. Keep in mind there are a ton of reasons, case law that comes in and supports both sides, whether this would support the suppression or go against the suppression, helps the defense, helps the prosecution of various certain situations about, especially, the police lying or being truthful, and the level that somebody actually relied on what the officer said. Anyways, a home is searched pursuant to a search warrant. The warrant application is based on an affidavit that contains several materially false statements because the police used an affidavit from an earlier case and did not revisit it to fit the facts of the current case. This happens kind of in raids. They will go through it and search multiple places, multiple homes, multiple houses that have been used in a drug dealing scheme, and they kind of use the same information over and over and over, copy and paste per se. And police, are busy, and they try and get these warrants as fast as they can, and they don't double check their work, which is why it's on your defense attorney to review the warrant and the affidavit that was submitted to the judge, and see if it was actually true statements in that, or if it was just completely made up. Next scenario, a search warrant authorizes the search of a home for stolen TVs. The police open a dresser drawer where a stolen TV could not possibly have been hidden and find drugs. This is a classic example that we go and study in law school, where they are, for instance, in this scenario, looking for TVs, and they start opening all these dressers and drawers and all these things where they find other evidence of paraphernalia of drugs. But the search warrant said, no, you're only allowed to go in and look for TVs. Granted, they make an argument that there parts of the TVs could be found in these drawers, and defense makes the argument that it's all beyond the scope. So it's one of the common scenarios, though. Next one, the police knock on the door of a house to talk to residents. They do not have a warrant. No one answers. So they go around to check the backyard and enter an area that is fenced off, posted with a no trespassing sign, or surrounded by a hedge where they find drugs. So basically this is, the police have no reason to be there. They just want to go and talk to the residents. They're, looking to see if anybody's there, if anybody, is hopefully healthy, safe, whatever it is. They go around the house and they kind of keep looking in. This is where they're going to be, peering through, open windows, keep your blinds shut. In the backyard, people leave things on tables, around pools, all kinds of different things. And they're going to try and say that they now saw it. Of course, as I mentioned before, there's the plain sight exception, but these are all things that interplay. This is why it's very complex, and you need an excellent defense attorney to really clear all of this up. The next one, the police bring a drug-sniffing dog up to the window of a house, and the dog alerts on drugs that could potentially be present. The U.S. Supreme Court has ruled that police cannot bring a drug-sniffing dog up to the door of a home in the hopes of creating the probable cause to obtain a search warrant. That's going to be the Florida v. Jardines case. Keep in mind, vehicles are a different scenario. A person was arrested after emerging from a house or an alley that the police were watching because of a suspected drug activity. Drugs were found in his backpack, but the police never saw him engage in a handoff or other suspicious activity before arresting him. It's very common because police want to basically arrest anyone and everyone, and once you're arrested, they're going to look for any reason to search you or to find any drugs, even if you're innocent. So it's kind of got to know your rights. In another video that I explain your rights and things you should do when the police contact you. Anyways, the police often stop cars for minor traffic violations and then look for justifications to search the occupants or the car for drugs. Some of the examples are the motor vehicle searches that can and should be challenged with a motion to suppress because the police arguably exceeded their authority. The police stop a car for minor traffic violations, not using your blinker, making a wide turn. The driver is cooperative, his license and registration are in order, and he is not wanted for any crimes. There's no warrant out. The police order him out of the car and give him a pat down for the officer's safety, is what they're going to say. And then they find a small quantity of drugs in his pocket. The police never saw any of the evidence that the driver was armed. No crime had been reported in the vicinity, and the area is not a high crime area. Basically, they should have just cited this person and let them go. And they didn't. Typically, this is where it's incredibly hard to prove, and we get into the Brady list and some other videos, but essentially this police misconduct hopefully has been reported against this officer in the past. You can get that information. It's very hard to get, even though it's not supposed to be, but essentially what we're talking about here are the very the racial profilings, the economic profilings of when police pull people over, and they are more or less going to assume that they have drugs and pull them out of the car and search them and find it. Of course, with body cams these days, it helps resolve some of these problems. Next one, police stop a car for a traffic violation. No drugs or weapons are found when the occupant is patted down. However, the police then search the passenger compartment of the car for the officer's safety, and then they find drugs. Again, the occupants were cooperative. The area is a low crime area. Prosecutors always like to say, and the police like to say, "Oh, this is a high crime area, so it's just for their safety." And we know that there's drugs dealt here all the time. Blah blah blah. The police never saw any evidence of weapons in the vehicle, even though the headlights of the squad car gave them a good view of the car. This is where they basically, police will like to say, oh well, we thought there could have been some kind of weapon in there, and so we were just searching for our safety. This is where you definitely don't admit to anything. You invoke your right to remain silent, and you're calling a lawyer who's going to tell you, hopefully, not to say anything, because good chance we can get a lot of it suppressed, and then the case gets dismissed. Next scenario, police stop a car for a traffic violation and arrest the driver for driving without a license. The police leave him standing next to the car uncuffed while they search it and find drugs. They know that if they had cuffed the driver and put him in the squad car, they could not legally have searched the car. The Supreme Court has ruled that this vehicle cannot be searched when the occupants are handcuffed and not in an area where they can access a weapon or evidence in the car unless the offense of the arrest provides a basis for the search. Arizona v. Gant, U.S. Supreme Court case, another big one that we study in law school. Essentially, if you are in handcuffs, you're no longer a threat, and especially if you're in the back of a police vehicle. And so the police can't use the fact that it was for their safety, and it was with the vehicle was within the driver's reach. Well, it really isn't, because you're in handcuffs in the back of a squad car, and the police are not allowed to do that. So they try and trick it and let you stand around the car. That way they can search it. So I know this is kind of advanced, but if you're thinking that this is happening, the further away from the vehicle you can get without looking like you're fleeing, it might sometimes be in the best interest. Of course, this is very advanced, that if you knew this or didn't know this, it's also a very case-by-case scenario that's going to be up to the judge to rule on in the motion. Finally, police stop a car for a traffic violation. After checking the driver's license and registration, instead of writing a ticket, they detain him for 15 minutes for a canine unit to arrive. They let a dog sniff around the vehicle, and when the dog alerts, they search and they find drugs. Although the police can allow a dog to sniff around a vehicle during a legal traffic stop, prolonged detention to wait for a canine unit is unlawful. This is a not very new, but it's a newer decision that came down, essentially saying you can't prolong stops. The scenario was with a canine dog sniffing unit where you pulled them over for really no reason, and they should have just given him a ticket and let him go, and then they called in for backup and waited for the canine to arrive. Now, there can't be any prolonged reason to prolong the stop. Now, if you're being pulled over and cited, and it just by happenstance the canine unit shows up at the same time while you're citing and alerts, the officer didn't prolong it. So a lot of fine details in this that your lawyer will want to go through. That is the main overview. And I know we're touching on so many different scenarios and rules and case law, on getting a motion to suppress into the judge's hands and being successful with it. So if you are dealing with anything like this in your case, or someone that you know or a loved one, and something along these lines happen, I mean, it's crucial to hire a private criminal defense lawyer if your public defender isn't handling it the right way, in order to resolve this, in order to get your case dismissed, get charges dropped. Of course, you know, this isn't a guarantee that it'll happen. Every case is different, and there's so many variables that are in every case. It's still just very important that you do what's best for you. Now I will end this video, and we will move on to a second video that will continue with what we're going to do with the prosecutor.